Hello and welcome to this week's edition of the Life and Legacy Show, sponsored by the Sechler Law Firm, where great families make great estate plans. I am recording this week's episode live at our brand new education center that we use to host all of our weekly workshops and our Red Wagon Club events that we have, which I'll explain to you here in a bit. And we're super excited to have this space. We just took this brand new meeting space that if you're watching on YouTube, you would see behind me, that we can use to now educate our clients, future prospective clients, on the things that they need to know about estate planning and protecting your family. And that's one of my passions. One of the passions that we have at the Sechler Law Firm and why we do this radio show called the Life and Legacy Show is to help you understand what you're up against in the battle to protect your family and your finances. And we are also here to help you put together just fantastic estate plans. But that requires some education, which means we need to teach you some things. So on this week's radio show, we've got an interesting topic for you. I just was doing a class for some of my existing clients on this topic matter, and I thought, man, this is something that other people need to hear. So we're gonna chat about it on today's episode, and that is the Filial Support Law, the Pennsylvania law that could hold you responsible for your parents' long-term care costs. And we're going to wrestle with this thing today and talk about what it is and talk about what it is not. As we get into the subject matter, let me just take a second here to introduce myself and my law firm to you. My name is Tim Sechler. I host this radio show each and every week, giving you the information you need, whether you decide to work with my law firm or not. That you need to make good decisions. I own a thing called the Sechler Law Firm, which is headquartered in Cranberry Township, but supports families all across Western Pennsylvania with their estate planning needs. And we do this radio show to just give you some information, but you got to understand this is for your information. This is for your education. I am a lawyer. I am not yet your lawyer. And so this is just not legal advice. It's information that I think you need to know, whether you decide to work with my law firm or not. And so the topic today is a thing called the Filial Support Law, which is absolutely crazy. When people learn about this, they can't believe that this is true in Pennsylvania, but this is the way that it works. So the Filial Support Law is a law that stands to hold family members responsible for their other indigent family members. Okay, so an example that comes up quite a bit is that an adult child could be held responsible for their parents' nursing home costs if proper planning is not in place. So let's dig into this. So this is craziness, right? I mean, what do you mean I could be responsible for my mom's nursing home? Is this new? Is this, and it turns out that the Filial Support Law has been a law, or some remnant of the Filial Support Law has been in existence for pretty much the entire time Pennsylvania has been in existence. But the thing is, it just never really came to be a cause of action. It never came to be a thing that care providers were going after kids for mom or dad's care costs. And maybe that's because the family demographics were different in the past. You had the adult child caregiver. Maybe it's because, people didn't live as long, right? People used to die in their 50s of heart attacks. Now we're dying in our 80s and 90s from dementia. And obviously an overgeneralization. But here's the thing. This is just my opinion, we have a broken care system when it comes to taking care of our seniors in this country. We got people, the baby boomer wave is reaching their retirement years and their senior years. And as this massive population comes, who's going to take care of them is a question that I think we all need to be wrestling with a little bit more. And in your own family, if you would need care, how are you going to pay for it? Nursing homes in this state can cost $150,000 a year, and most families are not prepared for that kind of financial threat in retirement. And it's not the nursing home's fault. The nursing home is providing valuable care. We need the care. Nobody's in a nursing home unless they need the care. And so if we need the care, how do we get the care that we need without going broke? And I think that's an interesting question that a lot of families need to wrestle with. And as they're approaching their retirement years and as they're thinking about estate planning, because see, estate planning is not just about answering the question, who gets my stuff when I pass away? Estate planning also makes sure that if those people inherit that money, that it's on favorable terms. We're not going to give them some problem, like giving money to an underage person or to a disabled person or to a person who's currently subject to a lawsuit. We got to be careful with these things, because what we don't want to do is live pretend that we live in a fantasy world where everything's always perfect and kids never go through things like divorces and whatnot, right? We need to live in reality, and reality is this stuff happens. And if my kid has something going on when I pass away, I don't want to just give them a bag of money to put on top of that fire. I want to do some better planning to make sure that the money actually does good things for my child, not exacerbate whatever problem he or she has going on. And so that's the type of thing that we teach you in our estate planning workshops, in how to protect yourself, protect your fund, your funds. But let's talk about this filial support law. So what is it? It's a law that says that if there's an indigent person and someone else is taking care of the indigent person, which could be a nursing home or some other care provider, if somebody's taking care of an indigent person, that care provider can pursue compensation from the spouse of the indigent person, the adult child of the indigent person, or from the parent of an indigent person. Now, the people who drafted this law didn't see fit to define what an indigent person is. And so I think that's one thing that could be debatable. But there's very little carve out. So the amount that you can be held responsible, it's 6 times your monthly income. Every year you could be held liable for an amount of 6 times your monthly income. So let's say that we had somebody that made just to make the math easy, $120,000 a year. That person makes $10,000 a month. They could be held responsible for 6 times that monthly income to pay for their dad's care. And the care provider doesn't have to prove anything. They don't have to prove I talked to my dad in the last 20 years. They don't have to prove that I love my dad. They don't have to prove that he's talked to me. They don't have to prove any of that. The only thing that they have to prove is that he's my dad. Now, I could make an argument that says I don't have the financial resources to do this. So there's a little carve out, there's a little rule that says that you can't hold somebody responsible if they don't have enough money to be responsible, but they don't really define what that means, right? And so, with some laws, the legislature passed a law, and then there's all types of interpretation. There's all types of regulations of the government agency that is here to enforce this law. There's case law. We don't have a ton of that with this filial support law. It basically just says you're responsible for your dad. And the case, the care providers never really used this thing until 2014. There was this case called the Pittas case. You can look this up. It made CNN and all the other news outlets. It's Pittas, Pittas. So what happened was Mrs. Pittas ends up through a car accident in a nursing home. She needs some care. She needs a rehab stay in the nursing home. So she goes to a nursing home. They're taking care of her. They're racking up a bill. She's not paying for some reason, and the reason for that would only be speculative, but she's not paying for her care. Then she apparently is discharged from the nursing home without having paid her bill, and she moves to Greece, where apparently her husband is living and a couple of her children. So she leaves this nursing home stuck with a bill of about $93,000 that she never paid for, and she left the country. All right. So now here's the nursing home. You got to for a second put yourself in the nursing home's shoes. Here's the nursing home. We provided this care to this person. The bill is $93,000. She's skipped town, essentially. She's not paying her bill. She's not responding to our communications. How do we recover the $93,000 we're owed? And out comes some lawyer out of the woodwork who says, I got an idea. We have this thing called the filial support law in Pennsylvania that says that adult children can be held responsible for their parents' care. And you know what? She has a child living in Pennsylvania. So now the adult child is sued for mom's $93,000 bill. So here he is. He's like, whoa, 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 whoa. What do you mean? I didn't receive any care. I didn't know my mom didn't pay you. It's not real clear to me based on a record if they knew each other, if they were getting along, if he was in on it. Like, I don't know what was going on other than he fights this bill. And so it goes to arbitration where he wins and they take it to trial court. And trial court rules in favor of the nursing home because a strict reading of this bill, he is responsible. He's a child. Mom apparently was indigent. Skipping town apparently meets the qualification of indigent, but maybe she really didn't have any money. Who bought the plane ticket to Greece? I don't know. But she doesn't have any money. She's gone. They sue the kid. He loses a $93,000 lawsuit. He appeals it up through the Pennsylvania courts. He loses a $93,000 lawsuit, which means we now have a case on the books in Pennsylvania that held him responsible for her nursing home care, even though he had presumably nothing to do with any of this. And that's some pretty scary stuff. Now let's talk about where it could actually really happen, because probably in your family, your parent is not going to skip town and go to Greece. So what's a more realistic situation where an adult child could be held responsible for their parents' care costs? And it seems to me like the most likely thing would be that a person ends up in a nursing home, a parent ends up in a nursing home, and for some reason is ineligible for Medicaid benefits. They apply for Medicaid benefits, they're not eligible. And so now the nursing home is not being paid by the state, and they're going to look for other recourses. If they're being paid by the state, they have to take the state's money. So if the person is eligible for Medicaid, kids don't get sued. But if Medicaid is denied coverage, now we might have a situation on our hands. So why in the world would a person not be eligible for Medicaid? Well, one of the things we talk a lot about here in our estate planning workshops is Medicaid eligibility, how you can get the government to pay for care without going broke in the process. Because Medicaid takes a look at your assets. Now, understand Medicaid is an imperfect system. There hasn't been a major overhaul to the Medicaid system in 60 years, and it was not designed to be America's safety net. But there was never a group of smart people. Like there was never a room with a whole bunch of smart people in it trying to figure out how do we take care of our seniors in this country. It's just this thing grew, but with like putting little Legos on top of this ugly stack of Legos that's already there. And then that's called Medicaid, right? And Medicaid looks at your assets. And so what happens is because people know that Medicaid looks at your money, there's this thing that occurs where when people hit a certain age, they think about giving their stuff to their kids, right? I'm now of this certain age. Maybe I'm just going to give my stuff to my kids because I know if I end up in the nursing home, they look at my money, so I just won't have any, right? Well, okay, but Medicaid doesn't want you to do that. You can't give away your money on Tuesday and ask for Medicaid to pay your nursing home bill on Thursday. It doesn't work that way. The way that it works is Medicaid's allowed to ask if you've given your money away in the last 5 years. And if the answer to that is yes, I have given money away in the last 5 years, then you will be denied Medicaid coverage for an amount of time based upon the amount of money you give away. So let me give an example. Let's say mom or dad gave a $300,000 home to their kids, 300 grand, and then dad needs care in the next 5 years. So what Medicaid does is they're going to divide the amount of the gift, $300,000 home, by the average monthly cost of a nursing home. Let's just for today call it $15,000 a month. So if you divide $300,000 by $15,000, the answer is 20 months. For the next 20 months, you're not going to be eligible for Medicaid benefits because the money's gone. Got it? So now we're not eligible for Medicaid. Dad is in the nursing home, not eligible for Medicaid because of the transfer. The nursing home finds it awful difficult to get rid of dad. He's not paying their bill, but they got to find a safe place to go. And the other nursing homes know that he's a non-payer and he's not eligible for Medicaid. And they have to find a safe place for him to go, but there is no other safe place for him to go because he wouldn't be in the nursing home if he didn't need a nursing home. So we got no safe alternative. We got none of the other nursing homes are going to take this guy who's not paying his bills. And so we're stuck with him. And so time starts going. So if he gave away $300,000, that's a 20-month penalty period. For the next 20 months, Medicaid doesn't pay for care. Well, the bill racks up to $100,000 or $200,000. And the nursing home gets this big unreimbursed bill. Now they got to look for somebody to pay for it because they have to run at a profit. They've got to make money. They got a payroll to pay. And so they start looking around for another way to pay for this nursing home bill, and they discover, oh, this guy that's not paying his bill and is not eligible for Medicaid, what about that kid they gave the house to? He's here. We know he has an asset. Let's sue him. And they sue the adult children for this care bill. And according, if the case goes the way that the Pittis decision went, the kid is going to be eligible for the care cost. Now, this is a pretty ugly scenario I'm painting for you, but it's a scenario that happens from time to time in the state. So how do you avoid it? Well, one, in our estate planning and asset protection workshops, which you should attend, by the way, go to sechlerlawfirm.com and go to the workshops tab and register to attend one of our free upcoming workshops here in our education center, where we're going to teach you all this stuff. We're going to teach you about wills and trusts and powers of attorney. We're going to teach you revocable trust versus irrevocable trust, and how you can use these different estate planning tools to protect your family so that you don't end up in a situation like the one that I'm describing. This is a free workshop, folks. We teach it pretty much every other week in our education center in Cranberry. You can come, you can enjoy a great conversation, cup of coffee, learn a bunch of stuff. No obligation. You can't buy anything here during the workshop, and so just come and learn. But one of the things that we would teach you there is we don't like to have our clients do outright gifting to the kids, because even if your kids mean well, right? If your kids mean well, what do I mean by that? Your kids want the best for you, right? So you've got a kid that lives across the street, and she's great. She helps make you dinner, and she cleans your house, and she takes care of you, and you trust her immensely. And so it's like, hey, let's give her the money. Let's move the house into her name. Let's give her $300,000, right? Now we need care in the next 5 years, and we can fix the problem. So anytime that you've transferred assets, Pennsylvania will allow you to what they call cure the gift. The money can come back to mom and dad, reducing the problem, reducing that penalty period. Because if we gave away $300,000 and she gives back $200,000, now the net gift is only $100,000, and we can reduce that penalty period. We can reduce that amount of time where Medicaid is not paying the nursing home. Okay, so it's called curing the gift. But here's the problem. The daughter means well. The daughter is a good kid. The daughter would gladly give the money back, except here's the problem. She can't, because something has happened in her world to where she can't give the money back. 5 years is a long period of time, right? Think about your last 5 years. We had COVID crisis in the last 5 years. We had people losing their jobs in the last 5 years. We had lots of people who passed away in the last 5 years. And so if you give your stuff to your kid, what if they can't give it back? What if I give my house to my kid and she dies, right? Imagine a scenario where I've got a daughter and a son. I put my house in my daughter's name, but she passes away. She's in a car accident. What does her will say? Her will probably says everything to her husband, my son-in-law. So now I no longer have a daughter. I have a son, but my son-in-law owns the house that I'm living in. And now I need to go to the nursing home. And Medicaid says, well, you gave this house away in the last 5 years. We're going to impose a penalty period. And had it been your daughter, she would return the money. But here's this son-in-law. And your son-in-law and your son, they never really got along, right? They played on opposite high school football teams. They hated each other. Your son is always mad that this guy dated and married your daughter. They don't like each other at all. And your son-in-law refuses to give the house back, because he looks at this and he says, well, wait a second. The filial support law says that your children are responsible for your nursing home bill, but it doesn't say your son-in-law is responsible for your nursing home bill. So son-in-law says, I got nothing to do with this. For all I know, my wife wanted me to have this house. I want to follow her wishes. I'm going to keep this house. And then the nursing home sues your son, and your son says, well, I didn't have anything to do with this. And the state and the nursing home say, well, too bad. We don't really care why the house was given away and to whom. This isn't about a fraudulent transfer. This is a law that says you're responsible for your dad. Your dad's in a nursing home. He's not paying his bills. Medicaid's not paying the bills because of this transfer. And so now your son is going to be held responsible for this nursing home bill. And so, this gifting of the stuff to the kids is pretty risky business, because 5 years is so long. People do pass away. People get sick. What if your kid goes into a nursing home? What if your kid becomes disabled? What if your kid's in an accident? What if your kid gets sued, goes through a divorce? There's so many different things that could happen to your kid that would disrupt your child's ability to return the gift. Now we got a penalty period. Now we got a potential filial support problem, and the lawsuits could start flying. And so one of the things that we'll teach you when you come to one of our upcoming 3 Secrets to Protect Your Legacy workshops is that outright gifting is not always the name of the game. It's probably not the smartest way to go about doing this because of, some tax reasons we really haven't gotten into in today's episode. but also because of this filial support law. I'm not a huge fan of you just giving your stuff to your kids' names, but I'm also not a big fan of you going broke in a nursing home. I understand wanting to protect assets from long-term care expenses. It's why I do what I do. My own family had this problem. But you don't give the assets to the kids. You put the assets in a trust. And this certain type of trust that we call an asset protection trust can be used to protect assets from this broken government system without the risk associated with transferring stuff to the kids outright. And so I'm a big proponent of middle-class families considering doing asset protection trusts because just a quick review of the statistics tells you you had better be concerned about this. If you listen to the Alzheimer's Association, 1 in 3 of us are going to have dementia. 2 out of 3 of us will need some form of long-term care. 2 out of 3, most of us. And for 20% of us, according to longtermcare.gov, this is government statistics, according to longtermcare.gov, 20% of us will need long-term care for more than 5 years. And according to the Department of Human Services, nursing homes cost about $150,000 a year. So you start adding this up, like, oh my gosh, I got a 1 in 3 chance of having dementia, 2 in 3 chance of needing some form of long-term care, 20% chance of needing that care for more than 5 years. And nursing homes are $150,000 a year. Something's broken. I don't like this risk. It sounds like the house could potentially catch on fire real soon here, and I'm not into house fires. And so that's why we teach our clients that estate planning is not just about who gets my stereo when I pass away. Estate planning is making sure I get the care that I need on my terms, not having the terms dictated to me. If you want a private room, go get the private room. If you want to stay in your house as long as possible, you should be able to stay in your house as long as possible. But you gotta be smart with the planning. You gotta be smart with the money. And if you're smart with the money and how you set up your affairs, you can make those dreams come true. You can make those wishes come true. But if you're not, if you just accept whatever system, whatever care these guys are going to give to you, I'm telling you, it's not going to work out great. The system is sort of rigged, right? And it's rigged against the middle class because, I've got nothing against indigent people, but indigent people tend to get the government care for free. Medicaid, if you don't have any money, you're on Medicaid. Wealthy people, and I have nothing against wealthy people. I'd love to be a wealthy person. But if you got $20 million in your pocket, you're not really worried about the nursing home issue, are you? So probably not, right? But it's the retired school teachers, it's the retired firefighters, service members, it's your middle class folks who are getting burned on this thing. And I don't believe that people work 30, 40, sometimes 50 years trying to save a nest egg, raise little humans, be good people, help others, open doors, support your favorite charities. I don't believe that people spend their lives trying to be good humans, that they should be rewarded in their senior years with a broken healthcare system that takes that legacy away. For the life of me, I can't understand why we haven't been able to fix this problem better. But I don't suspect anybody's working real hard to fix this problem better. It is what it is, and you need to protect yourself. And if you would like to learn how to do it, let us show you how to do it. Come to one of our 3 secrets to protect your legacy estate planning and elder law workshops, where we're going to teach you about the legal tools, the wills, the trust, the power of attorney documents, the different ways to structure your affairs to have this work out better, to protect assets, to make sure that your spouse has a home to live in and some money in the bank. A home to live in and some money in the bank is one of the things I talk a lot about at the workshop because, that's kind of the basic pledge. I've been married going on 18 years. And one of the things that I think about, and I do this for a living, right? I'm always thinking about this stuff. But basic duty as a husband is to make sure that my wife has a home to live in and some money in the bank, and it doesn't necessarily mean a mansion, and it doesn't necessarily mean, money to do whatever the heck you want at any point in time, though I'd love to have those things. But the basic ability to have a happy retirement, I believe, from a financial standpoint, should not be jeopardized by some broken government rule book. And I'm here to tell you there are ways you protect yourself. You just got to take action. If you sit on that couch and you back burner this, you're going to get whatever rule book they throw at you. And I don't want that for you. I want you to have the opportunity to do it better. So today's episode, I hope you found it empowering. I hope you found it eye-opening. I hope you learned something. But remember, this was not legal advice. This is for your general information. If you've got questions, you should reach out to us. Go to sechlerlawfirm.com, Sechler lawfirm.com. If you agree with the things that I'm saying, let's get together. Let's figure this thing out and let's protect your family. Sechlerlawfirm.com. Thanks for listening.